I vaguely recall that case, yes, sir.
And were you reversed by a higher court there too?
I believe that our report and recommendation was not adopted in full.
Okay, I don't have time to finish this list. I mean, it's longer than King Kong's arm here. You've been reversed a lot. In fact, you've been nominated before, haven't you?
What you just watched is one of the most uncomfortable and revealing judicial confirmation moments we've seen in a while. Senator John Kennedy didn't raise his voice, he didn't insult anyone, and he didn't editorialize. He did something far more devastating. He read the record, line by line, case by case, straight to the nominee's face. This hearing wasn't about personality or politics. It was about competence, accountability, and judicial consistency. And whether people like it or not, Senator John Kennedy came prepared, armed with facts, reversals, and appellate court language that speaks for itself. I'm Audrey, this is Congress Lens, and if you believe judicial nominees should be scrutinized with real evidence, not vibes or resumes, make sure you like this video, subscribe to the channel, and turn on notifications so you don't miss our next breakdown.
Senator Kennedy. Thank you, Mr. Chairman. Congratulations to all of the nominees. Judge Mahalchek, you remember a case called Yentzer v. Potter County?
I have a recollection that I presided over that case. I don't know if I recall the details of it.
Okay, and you were reversed, is that right?
I believe that was a case that I issued. I was a magistrate judge in that role and in the referral role on it, and it was reviewed by the district court, yes.
And you were reversed, right?
I don't recall in that case if the report and the recommendation was adopted in full or not adopted in full, but yes.
The higher court said you incorrectly analyzed qualified immunity and you incorrectly cited the 11th Amendment. Do you remember a case called Myers v. Clinton County Correctional Facility?
I recall that case as well.
And you were reversed in that case too, weren't you?
I believe it was adopted in part, yes.
Do you remember a case called Dennis v. Sheridan?
Yes, I believe I recall that case as well.
And you were reversed in that case too?
I believe that R&R was not adopted in full, correct? Yes.
Okay, but you were reversed.
It was not adopted, yes,
Is that
by
the
the
same
district
thing
court.
as being reversed?
It's a different. The district court declined to adopt the report and
The
recommendation.
higher court said you were wrong.
The district court disagreed with my report, yes.
Yeah, okay. Do you remember a case called Shania v. East Pennsboro?
Yeah, the Shanias are pro se plaintiffs who have brought a number of cases, so I'm not sure which one you're referring to, but yes.
I'm just curious, you were reversed in that case too, were you not? In
part, yes.
Okay. Do you remember a case called Spanier v. Libby?
Yes, I do.
The president of Pennsylvania State University was convicted of covering up child sex abuse crimes. And you let him go on a habeas corpus petition. And the Third Circuit reversed you, is that right?
I directed that a new trial should be held with a different jury instruction, and the Third Circuit disagreed and found that he had received the due process he was entitled to, yes.
Well, the Third Circuit said you failed to cite, analyze, or properly apply the relevant case law. You were reversed, right?
The Third Circuit reversed my decision, yes.
Okay. Do you remember a case called Hassel v. Centric Bank?
I vaguely recall that case, yes, Senator.
You were reversed, weren't you?
I believe the district court failed to decline to adopt my recommendation,
Okay.
yes.
Do you remember a case called Ramsey v. Amtrak?
Yes, I do.
And the higher court reversed you in that case too, didn't they?
The district court concluded that I was correct in finding that the petitioner did not pay a filing fee, and where I had recommended that the case be dismissed, he granted the petitioner 30 days to correct that.
So you were reversed in part?
Yes.
Okay. Do you remember a case called McCracken v. Fulton County?
Yes, I do.
You were reversed in that case too, weren't you?
I believe that was in part, yes.
You remember a case called Bird v. Britton?
I do.
And were you reversed in that case?
In part, yes.
Okay. You remember I'm sorry. You remember a case called Allen v. Lackawanna County Board of Commissioners?
I believe I recall that case, Senator.
And you
I'm not
were
sure.
reversed in that case too, weren't you?
I believe I was reversed in part in that case, yes.
You remember a case called Daniels v. Capital One Bank?
Yes.
And I believe you were reversed in that case too?
I believe it was, yes, I believe so.
Do you remember a case called Downey v. Pennsylvania Department of Corrections?
Yes, I recall that case.
And were you reversed in that case?
Yes, I believe I was.
Remember a case called Region v. Wetzel?
I vaguely recall that case, yes, sir.
And were you reversed by a higher court there too?
I believe that our report and recommendation was not adopted in full.
Okay, I don't have time to finish this list. I mean, it's longer than King Kong's arm here. You've been reversed a lot. In fact, you've been nominated before, haven't you?
No, I have not, sir.
Well, your nomination was talked about, and Senator Toomey refused to send in a blue slip for you, did he not?
I'm not sure exactly what happened. I know that this process has been ongoing for 2 years.
Yeah, but you know that Senator Toomey refused to even, thought you were so unqualified that he refused to even allow the Judiciary Committee to consider you. Isn't that correct?
I do not know what Senator Toomey's reasons were. So
You've never talked to Senator Toomey about it?
I never discussed it with Senator
And you
Toomey,
don't
no.
know anything about a blue slip being withheld on you?
I do not know.
You're under oath.
I am under oath, and I know I did not speak with Senator Toomey about his reasons for not.
Was Senator Toomey's concern that you were unqualified?
Again, Senator, I did not speak with Senator Toomey or his staff about his reasons for not supporting me.
Okay. Thank you, Mr. Chairman.
Now let's talk about what really happened here. After watching the entire exchange, one thing becomes very clear. Senator John Kennedy wasn't bullying anyone. He was auditing a judicial record in public. And that's literally his job. What Kennedy did was methodical. He didn't generalize. He didn't accuse without proof. He cited specific cases, specific outcomes, and specific appellate criticisms. Over and over again, the same pattern emerged. Decisions reversed, recommendations declined, legal reasoning rejected by higher courts. And notice something important. The nominee never once said, that reversal was wrong. Instead, the answers were carefully worded. Not adopted in full. Reversed in part. The district court disagreed. But here's the problem. In the real world, especially in law, a reversal is still a reversal. Appellate courts don't reverse decisions for fun. They do it when the law is misapplied, misunderstood, or improperly analyzed. The most striking moment is the Penn State-related case, where the Third Circuit didn't just disagree, it explicitly stated that the nominee failed to properly apply relevant case law. That's not a technicality. That's a red flag. And Kennedy's genius here is restraint. He lets the record do the damage. Every time the nominee tries to soften the blow with procedural language, Kennedy calmly brings it back to the same question. You were reversed, correct? By the time Kennedy jokes that the list of reversals is longer than King Kong's arm, it doesn't even feel like exaggeration, it feels like understatement. Then comes the blue slip moment, which is crucial. Kennedy points out that Senator Pat Toomey, a home state senator, reportedly refused to advance the nomination. That's not a minor political jab, that's an institutional warning sign. Blue slips exist to stop nominees who raise serious concerns locally. And the nominee's repeated claims of not knowing why the slip was withheld only deepens the concern, not resolves it. What this exchange really exposes is a broader issue in judicial confirmations today. Are we lowering the bar and calling it progress? Senator John Kennedy clearly believes the answer is yes, and after watching this hearing, it's hard to argue he's wrong. This wasn't grandstanding. This wasn't theatrics. This was oversight. And whether you agree with Kennedy politically or not, one thing is undeniable. If you're going to sit on the federal bench, your record belongs to the public, and Senator John Kennedy just made sure everyone saw it. That's it for this breakdown on Congress Lens. I'm Audrey, and I'll see you in the next one.